Seven, lucky number 7. I appreciate that you're all here. I think I'm streaming now. Welcome back. Sorry you're here on a Sunday, but you won't be here tomorrow. And I apologize it's raining. Let's see. 2 people are watching online, which I'm somewhat grateful for. And hopefully the rest of them will watch it later. You had your first Langdell yesterday. How was it?
Very good.
Good. Any questions? Anything you want me to ask? No? Okay. I don't have the projector on. The computer for the classroom, they change it apparently every semester. I don't know the new one. And there's no one here today, so we'll have to go with that. But I can still do a polling question even though I don't have the app open or the projection. So let me put a question up. Okay. It's not there, don't worry.
How are you able to tell that people are streaming?
Oh, I can say on YouTube. Oh man, oh this is not working for me today. God. Thanks for coming.
Added to the rest of the water.
When did it start raining?
20 minutes ago.
Okay, there we go. Okay, start polling session. Here we go. All right, so this is your question. Okay, the question is this. Article 3 of the Constitution allowed a citizen to sue another state in federal court. You guys see it?
Not yet.
Okay, good. Here's your question. Article 3 of the Constitution allowed a citizen to sue another state in federal court. That's your question. It's a question. True or false? If you can.
No,
What do you think, Utu?
because we know the answer.
Wow, I've never heard thunder the inside of the building before.
Of a building or
This building. Never. Although the building's really quiet, that might explain it, because there's no one here. It's completely empty. Anyway. All right. Tim, I think you're, I don't know where I am, but unfortunately, we'll be very intimate. The upshot is I did my 90-minute proper class in an hour, so it moves more quickly when it's only 5 of you here, or 7 of you. So Tim, what do you think the answer is here?
Honestly, I think the answer is debatable. It depends on whose interpretation you want to go with. I ended up choosing false simply because I was persuaded by Hamilton's argument in Federalist 81. And it's where he's discussing the power of the judiciary, and he lays out very plainly that, at least in his opinion, that states were not giving up their sovereign power. Plus, you can make an argument that the way that it reads is between a state and citizens in other states. Although Chief Justice Kerry was very persuasive when he talked about the fact that it doesn't matter what order they appear in. With Hamilton, I went with false.
Okay, very good, very good. I think that's actually a perfect answer. Not much more I can draw out than that. The The results right now are 50-50, 2 and 2, 5 and 5. I think people at home are actually voting, which is actually pretty cool. So I think the answer here is it has to depend, but probably the slightly better answer. I go back and forth. I go back and forth, but let me walk you through my thinking here, right? This is one of those questions where I don't think there's a perfect answer. Debatable is a good way of putting it. If you look at Article 3, Section 2 of the Constitution, right? It's on page, I'm sorry, on my projector here. If you don't have it, it's Article 3, Section 2.
49.
49? Thank you. And it says, the judicial power shall extend to controversies between a state and citizens of another state. And if you're hyper literal and technical, that only reflects the fact that the controversy between the state, which is the plaintiff, and citizens of another state, which is a defendant. It says nothing about a state suing its own citizen, right? And that makes some sense, because generally if a state wants to take action against its own people, it can sue them in its own state courts. But we know from CivPro, for example, that it'll be very strange for example, New York to sue a New Jersey resident in New Jersey courts. Why? There was a fear of favoritism and localism, right? That the local state courts would favor their own people. So it makes sense to give a state jurisdiction in federal court to sue a foreign citizen. That makes sense. But the more basic question, and this is what's implicated in Chisholm, is there some reason why it can't be flipped? That a citizen is unable to sue a state. Okay, so that question right here, it says nothing about suing your own state, right? It doesn't say anything about suing your own state. Directly, at least. But is there some principle, some rule, which prevents states from being sued, right? And this gives rise to this concept known as sovereign immunity. Sovereign immunity. Now, when you think of the word sovereign, you think of like the king, right? The king's sovereignty. And in England, there was this idea that the king can do no wrong. We've all heard this, right? Or as Mel Brooks would say, it's good to be the king. The king was considered almost godlike, and that he couldn't be subject to the law because he is the law, right? The king is the state. So if you had any grievance with the king, the remedy wasn't to sue him in court. If you had a grievance with the king, the remedy was to petition for grievances. That's where the phrase comes from, the First Amendment. Like you would file a petition with the king's court and say, "Hey, king, you're doing something I don't like," and the king would then take mercy upon you and say, "Okay, not because I have to, but because of my own decency, I will give a remedy to Mr. Smith for whatever reason." Okay. But the notion of sovereign immunity is somewhat inconsistent with our American system, right? How can we have a system where the states are immune from any lawsuits? Are the states on the same level as the king or not? And this question was our real first major constitutional debate. I mean, we're talking, Marbury was, 1803. This is 1793, so a decade before Marbury versus Madison. A far more important constitutional question, right? Wow, I've never heard it inside a building like this.
Have you looked at the writing too?
Well, I don't have a window in my office. I have no window, so I don't see anything. It's very depressing. Yeah, hey, come on in. So the question in Chisholm was, does our Constitution embody this principle of sovereign immunity? And if you look at the text of Article 3, it makes no reference to any kind of sovereign immunity. It just doesn't mention it. So the Chisholm case was really a a decision based on what's called first principles, right? The judges, and there were 5 justices, 5 opinions, right? We're all trying to reason from first principles of how to understand this concept of sovereign immunity in our own system. So just to cut to the chase, we'll do one at a time. But only Justice Iredell, which was the first opinion, accepted this notion of sovereign immunity, right? Iredell, though he was listed first, basically had a dissent. I think you have to read it as a dissent. At the time, that a tradition of opinions where instead of having one opinion for the court, they would do something called seriatim, S-E-I-R-A-T-I-M, seriatim, like serial, like one after the other, like a serial TV show. Each judge would write his own opinion, and then it was the responsibility of individual lawyers to figure out what is the holding. Right? Imagine that, right? I'm serious, right? You have difficulty. Oh, there's a majority, and there's a concurrence. What's the holding, right? Imagine having 5 opinions and trying to figure out what is the most narrow ruling. And this kind of came up in the Obamacare decision, right, where there was the Roberts opinion, there was the Ginsburg opinion, and there was the Scalia-Kennedy-Thomas opinion. And you guys were struggling over what is the damn holding of the case. Now imagine if there were 5 opinions, none labeled majority, none labeled dissent. Now, I know you probably say this is horrible. I actually liked him. John Marshall, I always get them confused. John Marshall changed the practice, and he decided to have an opinion of the court, which might sound very useful to law students. But by having an opinion of the court, it masks over disagreements that are sometimes important. And each of these 5 opinions has very different important views that simply just get washed over. So there's actually value to having seriatim opinions. In fact, Jefferson mocked Marshall for many reasons, one of which was having this idea of the opinion of the court. Oh, okay, yeah, 2, 4, 6, 8. Oh, we have 10. Good.
So first principles is because
there's not much to go on. Yeah. When I say first principle, I mean there's really not much else to go on. They don't have any sort of precedent of the court, right? There's no statute. There's no text in the Constitution that answered the question. They're going on very basic principles of how to interpret the law. I love these sorts of cases. It has no pollution yet. It's very, very smooth, very clean. All right. So Chisholm, even though it was a decade before Marbury, was a far more important decision. Far more important decision. Yep. Is it worse out there?
Oh, it's bad.
That's
Did
bad.
the door guy make a comment to you about your rain jacket?
No.
What did he say?
Oh, I walked in and our son, he went and he was like, I like your rain jacket. Like, it's doing you a lot of good, huh?
Oh, I don't care about your rain. No, I'm just kidding. I don't have an umbrella. I don't have a jacket at all. This is only jacket. I'll be in the building for a while, I think, until it stops raining. Okay, so let's do Chisholm, right? The facts of the case aren't that bad. Samantha, you want to give us, please, the facts in Chisholm?
The state of Georgia, sometime during the Revolutionary War, purchased clothing from a businessman in South Carolina, but they never paid for the purchases.
Nope.
So after the merchandise, the state took the case to the Supreme Court to try and collect from the state of Georgia.
Very good, very good. This was not an uncommon situation, right? During the Revolutionary War, lots of states took out lines of credit, which they never actually paid off. The surprising part is this case survived almost 25 years, right? It started during the Revolution, and then it stemmed all the way till after the Revolution, after the Articles of Confederation, all the way into the new constitutional government. It's remarkable this case even made it this long, but I think it was sort of a sore issue. So the basic question is, could Chisholm, who was a citizen of South Carolina, sue the state of Georgia in federal court? And by the way, they didn't just file this in a federal trial court. They did the same thing Marbury did. They filed this in the Supreme Court's original jurisdiction. So I know Marbury looked crazy for doing that, but it was actually somewhat common back then, right? And the question was, does then the federal Supreme Court have jurisdiction against the state? And again, if we look literally, right, if we just look at Article 3, straight up the text, right? Supreme Court has original jurisdiction, right, in controversies involving states, right? In all cases in which a state shall be a party, the Supreme Court shall have original jurisdiction. It says it right there. Georgia's a state, so then we go to the Supreme Court. Now, the harder question, though, comes in the previous page, right? Article 3, Section 2. Can a citizen sue a state versus a state suing a foreign citizen? So, let's start with Justice Iredell first. We'll do it in the order they appear in. What's Justice Iredell's analysis, please?
Sure. So basically, he said that the suit cannot be maintained, and that is because he gave 3 reasons.
Okay.
So the first reason is the Constitution did not mention anything about this. I think that's what he said.
Good.
Yeah. It did not prescribe any methods of proceeding in this case.
Very good. So what do we do when we have silence, when the Constitution is silent on this? What does Justice Iredell say we're supposed to do?
Read it now. I don't know. I made up that.
That's okay.
Figure out. So the second reason, no new law, expressly, no principles that all law must have. So in this case, the court will need to do analogy or precedent.
Well, what was the law before the United States, that Justice Iredell focused on?
That would be from their Britain.
Good. And what was the rule in Great Britain?
That the king cannot be sued.
Very good. Did anything in the Constitution change that rule?
I believe not for that.
Very good. So that's Justice Iredell's argument, right? He says the old law, the old rule, was that the king cannot be sued. And he says nothing in our Constitution changed that. Whatever sovereignty the King of England had upon the Independence Declaration, the states absorbed that sovereignty. Right? We've discussed this point before. Whatever powers the king had upon the Declaration of Independence, the states then absorbed that power. When the Constitution was ratified, the states surrendered some of that power. For example, regulating commerce, declaring war, a few different things. But whatever wasn't surrendered was retained by the states. That's the meaning of the 10th Amendment, right? Whatever powers are not delegated to the central government, the states retain. So Justice Iredell says, whatever sovereignty the king had, the people kept with the states. And therefore the states retained their sovereignty. And because nothing changed the old rule, therefore the states could not be amenable. They cannot be sued in federal court. If a state wants to let itself be sued, it can, right? States can waive their immunity. States can say, you know, we'll let ourselves be sued now. But they could not do it without their permission. Everyone with me? Yeah, Noel.
So I'm a little bit confused about who actually retains, because the people are not the state.
Oh, come back to that in about 2 or 3 minutes, okay? But let me give you a preview. It's a good question. Noel says, but the people aren't state. Under our Constitution, then, who is sovereign? Is it the states or is it the individual? And that's the opinion of the other opinion. That's Justice Wilson. We'll get to Wilson, though, in a few minutes. Okay? But Gerald, do you want to give me Justice Blair? His opinion was somewhat shorter. You probably love that one, right?
Rejected the sovereign theory that originated from England, that states gave up whatever sovereignty they had when they entered the Constitution.
Why is the European method not controlling here?
Because we went through this whole effort to get away from them.
Yeah, very good. Yeah, he has this one line I love. It says, "The Constitution of the United States is the only fountain from which I shall draw, the only authority to which I shall appeal." I think you should put that on my tombstone, something like that, or at least my water bottle. Maybe I should be good. You know, one before the other. So yeah, so Justice Blair is saying, like, we fought a war to get away from these people. We're not going to cite their law of sovereignty. If only that were true, though, because there are a lot of analogies between Parliament and our Congress, and there are a lot of analogies between the President of the United States and the King. So you'll see the court draw connections between the two bodies. So Justice Blair's opinion didn't quite carry the day, but it's a very nice imagery. Now, Noel, oh, perfect, you're next. Let's go to Justice Wilson. Justice Wilson is probably our most underrated framer, and I don't say that lightly. He was a Scotsman, but he was very, very, very brilliant. He was one of the most influential members of the Constitutional Convention. He was a member of the Supreme Court. He died, though, in debt, and in a very poor state. He was a debtor. So I think it was gambling. I might be wrong on that. But he had a lot of debt when he passed away. So he doesn't have sort of the legacy that a Hamilton would. But he was a very influential member of the founding Congress. So, Noel, walk me through just at a high level what Justice Wilson's getting at.
Wilson is pretty much saying that states are like people.
Oh.
And he basically talks about the issue of sovereignty, but that people are not subjects of the states like it was in England. Like they're not subject to the states; they're sovereign, independent.
Very good.
And then the sovereignty of the states comes from the people.
Very good.
And that's what the Constitution said.
Very good. Thank you, Noel. So Justice Wilson takes a very people-centric approach to the Constitution. When I say sovereign, like a king or a monarch, a sovereign has subjects, right? You're a subject of the king. And the king has basically control over you. But our Constitution doesn't begin with the sovereign, the monarch. It begins with we the people. And that's a line that he used, I think, very effectively, that introduces this new personage, the people. So if there's anyone who's sovereign in our government, it's actually the people. The states exist to protect the people, but the states themselves aren't sovereign. The state's inferior to man, he writes. So the notion of a sovereign state really has no sense in our legal order. What's majestic, the majesty, is the people themselves. And once you accept Justice Wilson's interpretation that the people are sovereign, this case becomes very simple, right? There's no legal principle defined in our Constitution that would prohibit a lawsuit against the state. And because there's nothing in the Constitution that prohibits such a lawsuit can go forward, right? Therefore, Georgia is amenable to this lawsuit. All right. Any questions on Justice Wilson? Very important opinion. All right. So Mia, let me ask you, what's Justice Cushing? Another fairly short opinion.
He said basically that there is express power in the Constitution for the controversies between those parties, and there's no reference whether the state is a plaintiff or a defendant, so the state can be sued or sue.
Okay, very good. So Justice Cushing, I think, has the most textual of the various opinions, right? He focuses most on the text of the opinion. And he says there's nothing here limiting the state to being the plaintiff versus the defendant, right? This is what we would call diversity jurisdiction, right? Where a citizen of one state sues a state of another state. It's diverse jurisdiction. You know, when you say this in civil procedure, it basically all comes from this case. Now, Mia, let me ask you a follow-up question, right? What if Chisholm sued Georgia not under diversity jurisdiction, but for a federal question? I'm giving a preview for a later case, but does this opinion say anything about federal question jurisdiction?
No, it doesn't touch on
Okay, and there's a reason why. For much of American history, the only way to get to federal court was through diversity jurisdiction. We have now today federal question jurisdiction, but that was a fairly recent innovation, right? The Constitution says for cases arising under the laws of the United States, you get federal jurisdiction. But Congress didn't actually create that statute until after the Civil War. It existed very briefly in the early years of the Republic, but they got rid of it pretty quick. So for much of American history, at least the first 100-odd years, the only way to get into federal court was diversity. There's nothing in here discussing federal question jurisdiction. And that would make a huge deal when we get to the Hans case in a couple of minutes. But just note that Justice Cushing there is only talking about federal diversity jurisdiction, not federal question jurisdiction. Yeah, I mean, you think you're Cifro again, but this stuff actually really does matter. Huge difference. All right, Clay, you want to wrap up and give me Chief Justice Jay? Justice Jay, by the way, was the first Chief Justice of the United States. He was also the one of the three authors of the Federalist. He actually left the Supreme Court to run for governor of New York, considering priorities, right? Upgrade. Although, again, Bill Clinton wanted Mario Cuomo, the New York governor, to go to the Supreme Court, and Cuomo turned it down. He wanted to be president, but never quite happened. Anyway, Clay?
Starts out with another people-centric approach.
Oh, I like that.
Just like the other Supreme Court justice. But when he says people acting as sovereigns of the whole country, and he uses the language, we, the people of the United States, do ordain and establish the Constitution. And then he also relies on the definition of controversy.
Okay. What does he say about controversies?
Between states and citizens and other states.
Very good.
Article 3.
Yeah. Yeah, and he also makes a point that I like drawing on. He says, look, if you can sue a city, why can't you sue a state? Right? And it's, you have a little bitty state like Delaware, right, which is like no one, and you have a state like Philadelphia, which is huge. So how can it be you can sue a city, but you can't sue a state? Anyway, I always thought the argument makes some sense. All right. So any questions on the facts in Chisholm and the 5 opinions? The aftermath of Chisholm is worth studying carefully. Okay, it's worth studying carefully. We all know this decision was unpopular. People didn't like the fact that a state can be sued. And then shortly thereafter, within about a year or so, they proposed an amendment to the Constitution. Right? So here's the chronology. The case was argued in February 5th, 1793. It was decided February 18th, 1793, so basically 2 weeks later. Bless you. By March of 1794, Congress proposed what became the 11th Amendment, so basically a year later, and it was ratified in February of 1795. So like within 2 years of Chisholm being argued, Congress ratified and proposed, and the people ratified the 11th Amendment. And that's significant, right? The people actually ratified something that reduced their own power. Just think about that for a minute, right? The people ratified an amendment that took away the power of people to file lawsuits. They ratified an amendment that strengthened the states. So what does it say about the people's own conception of the sovereignty of the states? All right, now let's look at the wording of the 11th Amendment. Some of the pages shout it out. Sorry, I don't have my screen up. I usually would project if I can't. 69, thank you, sir. So it says, Richard, did you find an error? Did you put that error into the video? Was that you?
Yep.
Very good job. I appreciate that. I didn't know you could even do that, but apparently you can. Thank you, that. So the 11th Amendment reads, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. This is probably one of the most controversial provisions in the entire Constitution. To this day, people don't get what it means. In fact, I saw Brett Kavanaugh give a lecture on this 10 years ago. And he's like, yeah, we don't really know what it means. We know what the court says, but the actual meaning of these words are difficult. I actually think that Kavanaugh was the first person to tip me off on this. I don't think I'd study this in ConLaw, but you will. Sergio, at the most basic level, right, what exactly did the 11th Amendment do? Just most basic analysis.
So
Says a citizen of another state cannot, a citizen of a state cannot sue another state.
Okay. So, in English, what was that like at most basic level?
States cannot be sued by anybody.
So, right, you're a citizen of Texas, right?
Uh-huh.
Can you file a lawsuit against Louisiana?
No.
You cannot. Okay? Exactly. That much is easy, right? A citizen of one state cannot commence, that means bring, right? Cannot commence a suit against another state. So you're a citizen of Texas, you then can't bring a lawsuit against Louisiana. Right? What this basically did was modify Article 3, Section 2. Article 3, Section 2 left this issue open. Article 3, Section 2 said, yes, a citizen of one state can sue another state. Didn't really specify, but here that chopped it off. A citizen of Texas cannot sue Louisiana. Can't do it. Louisiana can sue you, right? It doesn't go the other way. Louisiana can go sue Sergio in federal court, but Texas cannot, Sergio can't sue Louisiana in federal court. That much is straightforward, right? It modified Article 3, Section 2. But the much harder question, did this overturn Justice Wilson's opinion? Right? Did this overturn Justice Blair's opinion? Did this overturn Justice Cushing's position? Right? Which of the Chisholm opinions was reversed by the 11th Amendment? I think the only one was probably one that Mia gave me a minute ago was Justice Cushing, right? The textualist one. I think the 11th Amendment by itself reversed Justice Cushing's opinion, saying that it makes no difference if you're a plaintiff or defendant, right? Here it says the citizen cannot be the plaintiff. But the much harder question, but the much harder question is, did the 11th Amendment try to reverse Justice Wilson's rejection of sovereignty? Did it reject Chief Justice Jay's conception of sovereignty? Did it reject Justice Blair saying we're not looking to the European model of sovereignty, right? What exactly did the 11th Amendment do? And the text only goes, I think, to the textualist opinion. I don't think it mentions Justice Wilson or Chief Justice Jay. It doesn't mention. Mia, I'm sorry, I didn't want to cut in the middle.
No, I was just going to ask, did it really change anybody's opinion since it shifted the law?
Oh, what a good question, right? In fact, I think I spoke too glibly. An amendment doesn't actually overturn the Constitution. It merely changes the law that's to be applied. And this was Justice Harlan's position in Hans. We'll get to a little bit later, right? Justice Harlan said that Chisholm was correct at the time, but the 11th Amendment changed the situation. My point is, which opinion was it trying to change, right? And I think it was changing, without question, the textualist opinion from Cushing, about the plaintiff defendant business, right? But here's $1 million question. Did the 11th Amendment change the conception of sovereign immunity? In the Wilson opinion, in the Jay opinion. Let me ask the question one other way. Was Chisholm wrong the day it was decided? Right? If Chisholm was wrong, then do we need an amendment? Right? Now, one other question, Sergio, and I'll let you go. Is there anything in the 11th Amendment that stops you from suing your own state?
No.
Can you go sue Texas? You're a citizen of Texas. Can you go sue Texas?
Yes.
Does it say anything about this?
No.
So here's the riddle, right? On the 11th Amendment, Sergio can't sue Louisiana, a foreign state, but Sergio can go sue his own state, Texas. That's what it says. Right? Everyone with me so far? All right, so Kenesha, that brings us to the second case for today. Hans against Louisiana, 1890. Again, 100 years elapsed, 97 years. A century basically elapsed from Chisholm to Hans. And the reason why so much time elapsed is we did not have federal question jurisdiction. We just didn't have it. There was no basis to get into federal court. But once you have federal question jurisdiction, then you get yourself into federal court. Okay? So, Kenesha, you want to give me the facts, please, in Hans versus Louisiana? Please, by all means. Yeah, this is the one case where I deviate from the ordering of the case book. Randy teaches Chisholm the first week of class. I think it doesn't fit well enough, so I smuggle it in later. But you know, here it is.
So this one is, there was a citizen of Louisiana who sued
Again, the factor wasn't identical to Chisholm, right? These were debts that were incurred during the Civil War that were never paid off. It's basically the same exact sort of dispute that arose in Chisholm, except it's the Revolutionary War versus the Civil War. Any question, Chisholm? Got it. Very good. Well, so this case is often difficult for law students, and I get why. You have this amendment. It says one thing, right? Most of our amendments are pretty vague, right? We don't really know what commerce is. We don't always know what liberty means, right? There's some amendments that are fairly open-ended. But the 11th Amendment is pretty damn specific. It says something very precise, that you can't sue another state. But it says nothing about a citizen of Louisiana suing his own state. In fact, this is a lot of money. I did the math. It's almost $2 million in present-day value, right? It's a lot of money out of that issue. So Justice Bradley's opinion, I don't want to say ignores the 11th Amendment, but it basically pretends the 11th Amendment doesn't matter. Right? Jason, just walk me through the majority opinion, please. Okay, I want you to walk through the analysis, please. Okay, the 11th Amendment discuss suing your own state.
No, it doesn't.
So then how does the court make its ruling?
Okay, so he says that.
My mic is muffling, so I'm getting criticism from people not in the class. I love this. How's that?
She said it was.
He's saying that.
It's actually the microphone's here. It's clipped on my tie.
Okay, sorry.
All right. Well, if they're complaining, tell me back. Okay.
Okay.
Yeah.
So Justice Bradley is saying that he does admit that it's not in the 11th Amendment, but he says that it would be absurd that they didn't consider that when amending.
Good. So basically, it's like an absurdity argument, right? It's like, how could it be that the framers would be so stupid, right? The framers of the 11th Amendment would be so stupid to permit lawsuits against your own state, but not permit lawsuits against a foreign state. So it's this weird thing where they say the text doesn't really matter, right? The text isn't as important as what we think that they were trying to accomplish, right? And then we get to this weird part. Tim, which opinion in Chisholm does he cite of the five judges? Which opinion does he keep citing? No, which opinion does Justice Bradley cite from Chisholm? He cites Iredell, exactly right. And Iredell is the dissent. Now, again, Justice Iredell didn't make a big difference about whether it was a plaintiff or defendant. He said that the king was like the president. And the king was sovereign, and then the president was sovereign. So what the court's basically saying here is, The president has sovereign immunity. I'm sorry, this is not the president. The states. The states have sovereign immunity. Tim, if the states have sovereign immunity, does the 11th Amendment even matter?
No,
Bingo. Why not?
because if they have sovereign immunity, they would have to consent to be, they would have to give their consent to be sued in the first place. So
Very
you
good.
would read the 11th Amendment saying that they couldn't be sued.
Very good. Everyone understand what he just said? Say it again one more time. It's really correct.
Yeah. So basically, if they have sovereign immunity to not be sued and they have to give their consent,
Yeah.
you don't need any text saying that they can't be sued.
Yeah. The upshot of Hans v. Louisiana is that the 11th Amendment was unnecessary. If the states were sovereign, then they couldn't be sued by a citizen of their own or a foreign citizen. It didn't matter. If the states were sovereign, they could never be sued. And just so I want to understand this point, right? The upshot of Chisholm is that it didn't matter whether they're the plaintiff or the defendant. Hans says that Iredell was always correct. And because Iredell was always correct, it didn't even matter the text of the 11th Amendment. And that's to this day. We'll go to Florida Seminole Tribe in a couple minutes, but that's to this day the correct rule. I didn't sign them, did I? Bernie, Morrison, whatever. It's all the same thing, right? Florida Seminole Tribe, Morrison, Garrett, they're all the same. All the cases. It is in the video. All the cases presume that Justice Iredell was correct, and that there's always sovereign immunity. And there's always sovereign immunity. It doesn't really matter what the 11th Amendment says, right? It's a very strange position. Yeah, Gerald.
Okay, so is that why the majority basically says the 11th Amendment did not, in terms, because that's what sort of threw me off. It's what they say. 11th Amendment did not, in terms, prohibit suits by individuals against the states, but declared that the Constitution should not be constructed to import any power to authorize the bringing of suits of such. So essentially, I took that, maybe now it's a little bit cleared up, but it made me almost think, you just can't use the Constitution to sue a different state. It didn't say anything about still not.
Basically, Gerald, the point is, the idea of sovereign immunity predated the Constitution.
Right.
This was, I think, Samantha's question a couple minutes ago, right? If the states were immune upon independence in 1776, and the Constitution didn't change that, there's nothing in the Constitution that needs to address it, right? It merely preserved the status quo.
Okay.
And because the states never surrender their sovereignty, they maintain it to this day. Make sense?
Yeah.
The notion of state sovereignty is actually a fairly controversial one. I mean, it's very, it's so common and so deeply rooted in our legal tradition, we don't even question it. But its basis is really no basis in history. I think Justice Iredell was wrong as an original matter. I think Justice Wilson was correct as an original matter. The sovereigns were the people. But we built this entire elaborate framework on top of Chisholm and Hans that, it's sort of a moot point. And I want to draw your just attention to Justice Harlan, right? It's a fairly brief opinion. And he basically says, I agree that under this doctrine of sovereign immunity, the suit can't be brought, but I don't agree about Chisholm. I think Chisholm was correct at the time it was decided. So Harlan seems to say that even though sovereign immunity wasn't clear in 1793, after the ratification of the 11th Amendment, that embraced the concept of sovereign immunity, right? Even though the text of the 11th says nothing about sovereign immunity, by ratifying that, they were overturning the Jay opinion. By ratifying, they overturning the Wilson opinion, right? That the 11th Amendment was designed not just to overrule Cushing, but also Wilson and Jay. I think that's how Harlan reads it. And Harlan might be right, I don't know. But the majority can't be right. Yeah. I know it's frustrating.
No, never mind, because they went through the amendment process. I was just going to say, but wouldn't that then be Congress, saying
No.
that it's constitutional, but they went through the
You're allowed to.
amendment process?
You're allowed to. I mean, that's exactly, Mia's point is exactly right. If Congress doesn't like the way the Supreme Court makes its opinion, they can amend the Constitution. But they didn't just say, we're overturning the Jay and Wilson opinion. They just said what they said, right? If they had said, Section 1, the states are sovereign, period. Okay, then that's easy, right?
Or if they
Oh, I don't think you can do that by legislation.
Right.
Ah.
I figured that.
I mean, actually, maybe they could. I don't think you do it by statute. I don't think it would work. There might have been a way, but it didn't quite work. Okay. Okay, Ganesh, how's the audio? Are my minions in TV land complaining still? They're good. It's good? There are 12 people watching. I'm actually impressed. Yeah. So you're all here live. All right. So now, can you sue a state under current law? The answer is no, unless two things happen, right? So first off, a state can consent to a lawsuit. So let's just say, you get hit by a car driven by a state employee, right? You get hit by a car driven by a state employee. The state's not going to say, I'm sorry, that's really nice to get hit by a car, too bad, right? The state has what's called a claims process, where you can submit a claim against the state for a tort. And generally, the state will provide a forum for you to get some sort of compensation, if there's negligence, for example. But you can't just go to court and sue. You can't just walk into a federal court and sue. You have to go through this process where you obtain a claim. The same with the federal government, right? If, let's say, I get hit by a USPS, right, the post office. If a mail truck hits me, I can't just go to federal court and sue them. I have to bring a claims process, and the government gives me permission to sue after a certain point. So even given Hans and Chisholm, you can still sue a state with their permission. There's another exception which is not in the book, but it's worth mentioning. What if a state official is violating your constitutional rights? So you learned about 1983 in CivPro, Section 1983? You're nodding your heads? 42 U.S.C. Section 1983? So what you don't know, that was actually called the Ku Klux Klan Act. That was the origin. This was actually during Reconstruction. And the statute says, I'm paraphrasing, if any state official acting under the color of state law deprives you of your civil rights, deprives you of a right protected by federal law, you can sue that official in federal court. Now, wait a minute, Josh. Did we just say that the state can't be sued without its permission? Well, what happens? Congress stepped in and said, no, we're no longer going to stand by when state officials are depriving people of their civil rights. And we're going to let private citizens sue the state. Wait a minute, Josh. How can this happen? Right? If the states are sovereign, right? If the states are sovereign, just like the King of England, how can Congress step in and waive that sovereignty? The answer is found in the 14th Amendment. The 14th Amendment. Now, we haven't studied the 14th Amendment yet. It's basically the second half of the semester. After the midterm, I think we spend the entire second half of the semester on the 14th Amendment. But I need to give you a little bit of a crash course in the 14th Amendment. If you haven't yet watched the video, I encourage you to do it because it explains it with very pretty graphics. I will do my best. Let me have my screens here. I'll do my best, old school. But the 14th Amendment is the key, right? So a state can waive its own immunity under the 11th Amendment, or Congress can do it for the states, whether they want to or not. So we turn to the 14th Amendment. If anyone has a page, just shout it out, please. 73. Thank you, sir. All right. Again, we're going to spend weeks on the 14th Amendment. I'll give you a preview here. Section 5 of the 14th Amendment. There are 5 sections. Section 5 of the 14th Amendment gives Congress an important new power. It says, the Congress shall have power to enforce this article by appropriate legislation. The Congress shall have power to enforce by appropriate legislation the provisions of this article. Again, The Congress shall have power to enforce by appropriate legislation the provisions of this article. So far, all of Congress's powers have been listed where? Article 1. Bingo. Thank you. So far, all the powers of Congress are listed in Article 1, Section 8, right? Commerce and tax, 1 through 18. That list we've done 100 times. This is a new one. Following the Civil War, Congress proposed and the people ratified the 13th, the 14th, and the 15th Amendments. The 13th Amendment abolished slavery. The 14th Amendment guaranteed equal protection of laws and told the states they can't deprive people of due process and all these other good things, right? 15th Amendment guaranteed the right to vote regardless of skin color. But Congress that proposed these amendments didn't trust the states, right? They didn't trust that the states would honestly implement these laws, right? So they created a backup. Congress could enact legislation, appropriate legislation, to enforce these laws. Today we think of the 14th Amendment as something the courts enforce, right? Oh, Brown v. Board, all this stuff, right? That wasn't the original design. The 14th Amendment was supposed to be Congress's baby, right? If a state was denying people their civil rights, Congress would step in and enact federal legislation to implement it. Or Congress would step in and let people sue in the federal courts for the deprivation of their civil rights. That was a key function of the 14th Amendment. That the states, if they deprived the person of various civil rights, Congress could pass a law to allow a lawsuit against the state. We say that Congress waives a state's sovereign immunity. Waives a state's sovereign immunity. If you want a big fancy word, abrogate. 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 And what does that mean? On the 11th Amendment, the states are sovereign, but Congress can abrogate, can waive, can nullify that sovereignty. And the way this works is actually historical. The 11th Amendment was ratified first, and then about 5 decades later came the 14th Amendment. The later in time provision can trump the earlier in time provision. Whatever sovereignty is afforded by the 11th Amendment, Congress can kill. Now again, if I take a step back, right, and if I say that Hans is wrong, then all this stuff is stupid, right? If the states lack sovereign immunity, then we don't need to do any of this stuff, right? If the states aren't sovereign, then Congress doesn't need to waive it. But because the states are considered sovereign under Hans, we need to have Congress then have this power to waive it. So this entire doctrine of waiving sovereign immunity is premised on Hans being correct, which is why Hans probably will not be overruled, even though it's probably wrong. But everyone sees this, right? This entire doctrine with Bernie v. Flores and other cases is premised on Hans being correct. If Hans is wrong, Congress doesn't need to waive it because it doesn't exist in the first place. Right? You could sue your own state. Archbishop Flores, for example, could sue his own state, no problem.
I do have a question. Does Congress need to create a statute in order to waive their state's sovereign immunity, or they can just step in and say, oh, I waive the immunity, go ahead and sue?
Exactly right. Congress needs to enact a statute to waive a state's sovereign immunity. And the huge one they enacted was the Religious Freedom Restoration Act, which brings me to my first case. All right, but everyone get the abstract, right? Section 5 says, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. All right, everyone get that much? Okay? Yes?
So if, hypothetically, if Hans was wrong and it's 1890, the 14th Amendment was
68.
68? Okay, so the end of Reconstruction. So if Hans was decided incorrectly, but the 14th Amendment's already passed, but the 5th Section 5 of the enforcement clause of the 14th Amendment, would it just be unnecessary?
Well, Section 5 does a lot of other stuff, not just allowing lawsuits.
Okay.
It does a lot of stuff. I see your question. It does much more than waiving sovereign immunity. Kanisha?
Well, Section 5 doesn't say just waive sovereign immunity.
It does a lot of stuff.
It says that it enforce the provisions of the article. That's not the only provision.
Yes, ma'am.
So that would be a minor.
Yeah. Section 5 was really important. And when it says provisions of this article, it refers to sections 1 through 4. Right? Everything's section 1 through 4. For example, section 1 says that, you know, the states can't deprive someone of the due process of law. The states can't deprive someone of the equal protection of the laws. We'll talk about what this means later, but these are really important provisions. Right? The states can't deprive someone of the privileges or immunities of citizenship, right? So this was a catch-all provision that gave Congress a lot of powers. But as we'll see in Bernie, the Supreme Court... Is that me?
Yeah.
I'm on YouTube? Yeah. YouTube star, right? As we'll see in Bernie, the court would neuter Congress's Section 5 powers in, you know, in a fairly significant way.
But if it wasn't, if it was decided incorrectly, then that would mean that they would have said them in.
I'm sorry?
I'll ask later. Let me find it later. Thank you.
Okay. Yes, mine. Please.
So, in your opinion, what is the practicality of the 14th Amendment? Because, like, for example, I want to sue the state, but I need Congress to waive the state's sovereign immunity. Then I have to write to my congressman, and the congressman have to somehow persuade the state to pass the statute. And I might have just give up because that's too much work.
Well, so if you want to sue, if you have a problem with your state, right, you can write to your local legislator, and they can do it. Or you can have your own state waive its own sovereign immunities. Texas waives its immunity in a lot of different contexts. But because of Bernie, which we'll do in a minute, v. Flores, significantly limited whether Congress can abrogate a state's sovereign immunity. It's a very narrow scope. So today, it's very hard to sue a state because of Hans to this day. Make sense? Thank you. Other questions on the general gist? Right? So one of the provisions in the 14th Amendment is a due process clause. And it says, nor shall any state deprive any person of life, liberty, or property without the due process of law. Long story short, the phrase liberty came to be understood to reflect the first 8 amendments of the Constitution. I'm summarizing 100 years of law. But one of the provisions, the word liberty, reflects the Bill of Rights, including the Free Exercise Clause. Right? So if you go to the First Amendment,
You said the first 8, liberty refers to the first
8 amendments to the Constitution, which are traditionally known as the Bill of Rights. That term didn't exist at the time, but it came to be known that later. And if you notice, it said first 8 and not first 10. Why? Amendments 9 and 10 don't grant any rights. They were called structural provisions. Right? The 9th Amendment, we'll read it to you, says, it's Randy's favorite part of the Constitution. This is a baby. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. It's a rule of construction. If a right's not written down, that doesn't mean it doesn't exist. If a right's written down, that doesn't mean you don't have other rights. Right? It's a rule of construction, the expressio unius canon, if you would. And the 10th Amendment, we've discussed at length, says the power is not delegated to the United States, nor prohibited by to the states, reserved to the states or the people. Right? So the 9th and 10th Amendments don't actually, Randy will kill me, don't actually give people any obvious rights. Randy thinks there are rights there. I agree with him, but it's not obvious you can incorporate the 9th Amendment. But the First Amendment, you can, right? The First Amendment says, Congress shall make no law prohibiting the free exercise of religion. Congress shall make no law prohibiting the free exercise of religion. What does that mean? Right? Well, we have a couple cases. I'll summarize them for you. We'll come back to this the last week of class, I think. But we had a case in the 1960s called Sherbert versus Werner. And the facts of the case were like this. you had a Seventh-day Adventist. This is a faith that celebrates their Sabbath not on Sunday, but on Saturday, right? And as part of their Sabbath, they will not work on that day, right? So they won't work on a Saturday. You had a person who sought unemployment money from the state. And the state said, well, we'll try and get you a job. But you have to work on a Saturday. And the person said, no, I will not work on a Saturday. I said, fine. If you're not willing to work, you're able-bodied, we won't give you unemployment benefits. She sued and prevailed. And the Supreme Court said that even though this law is neutral, right, they're not targeting one religion over the other, it has a substantial burden on her religious exercise. And therefore, her rights under the First Amendment were violated. So that was Sherbert versus Werner. And that proved to be a fairly unpopular decision among conservatives, that courts were making exceptions to laws for religious exercise. Fast forward to, was it 91? 92, I was here. 91, right? Employment Division versus Smith. And this case involved peyote. Peyote is like a hallucinogenic cactus. It's used in a lot of Native American religious rituals. Then you have Mr. Smith, Al Smith. He was actually raised not in the Native American tradition, but later in his life he came back to it. And he found it gave him a lot of peace. He had actually had drug and alcohol addictions, and he found that this religion helped him find a sober lifestyle. And he worked as a drug counselor for rehabilitation. Unfortunately, part of his job requirement was not to do drugs, and he, in fact, did peyote, which is a controlled substance. He lost his job. Then he tried to apply for unemployment benefits. And the state of Oregon denied his petition for benefits. They said, because you were engaging in illegal conduct, it was against the law to use peyote, we're going to deny you the benefits. Now, wait a minute. Didn't we just say that the Seventh-day Adventists got the benefits? Well, the court more or less overruled Smith. I'm sorry, more or less overruled Sherbert. They didn't say it. They sort of distinguished it, but they pretty much qualified the Sherbert test. And what the court said is, if you have a law that's generally applicable, what does that mean? The law applies to everyone equally, right? It applies to Jews, Christians, Muslims, Hindus, doesn't matter. No one can smoke peyote. If the law applies neutrally, it doesn't matter if it imposes a burden on religious exercise, right? Laws of general applicability are presumed valid unless there's some evidence that there was specific animus towards one faith. And in this case, there was no evidence that Congress or the state enacted this peyote ban out of an anti-Native American bias. There just wasn't, right? So, I mean, long story short, to summarize briefly, the Smith case more or less overruled Sherbert versus Werner. Now, Smith proved to be extremely unpopular. And Congress responded to Smith by enacting a statute. The Religious Freedom Restoration Act, RFRA, pronounced RFRA, right? RFRA, my favorite acronyms. Second only to RLUIPA, Religious Land Use and Institutionalized Persons Act, RLUIPA, my favorite acronyms. God bless congressional staffers who make all these like acronyms. They're very good at it. RFRA, as its name suggests, tried to restore religious freedom. And specifically, they tried to restore it to what it was in the Sherbert versus Werner test, that is restored before Smith. Not exactly, they made some changes, but the overall tenor is they tried to bring back Sherbert versus Werner and other cases from the 60s. Right? And as a consequence, the law said that if a state imposed a substantial burden on a person's free exercise, that violated RFRA. And what happened? That person then could sue the state. So what RFRA did was it waived a state's sovereign immunity if a person's free exercise rights were violated. But here's the key point. it didn't just use the definition of the free exercise clause adopted in Smith. It provided a different, more expansive definition of free exercise that existed beforehand in the Sherbert test. So what RFRA tried to do was give citizens the right to sue their state for something that goes beyond what the Constitution required as interpreted by the Supreme Court. And that's the key point, right? It tried to give a different interpretation of free exercise. So Maya asked me a question before, can Congress pass a statute that allows these sorts of lawsuits? This case put a limit on that. All right, so we get the basic background. I have to just walk through that because it's not in the case, and there's no good way of explaining it otherwise.
So the case limited it limited
Yeah, exactly. It limited Congress's power to waive sovereignty. Exactly correct. Gerald, was your hand up?
No.
Is that Noah? Oh, I'm sorry, Sergio. Yeah.
Sorry, you said in trying to give a different interpretation of
The free exercise clause of the First Amendment. It tried to restore the Sherbert test in the 1960s, and it basically tried to ignore the Smith test in 1991. Ooh, there's no light here. Oh, no, that's not it. Okay. No one's here. All right. Who am I up to? I don't remember. Who's next? Samantha, you next? Samantha, you want to give me, please, the facts in Bernie Flores, please? But is anyone from Bernie, Texas, by the way? No, that's out of San Antonio, right? I think so. Anyway, go ahead, please, Samantha.
So a Catholic church went to that construction to expand their building, and they were denied a building permit.
Very good.
It being named a historical site, I believe.
Uh-huh.
And so they're sued under the Religious Freedom Restoration Act. City authorities relying on the ordinance. They were denied the building permit, so they brought suit under the Religious Freedom RFRA.
Very good. Very good. Okay, Samantha, let me ask you a question. As a general matter, right? You've taken property too yet or no? You haven't. Okay, well, take your best guess then. As a general matter, if you apply for a zoning permit from the city, and the city denies it, where do you think your remedy will lie? Can you go sue in federal court? Yeah, she's right. Good guess. You'll do this in property. As a general matter, if the city or the county denies you a zoning permit or a building permit, your remedy is to go through the city or county courts, right? Why? Because Texas has waived its immunity to be sued in its own courts for zoning disputes. You cannot bring a zoning dispute to federal court. That just doesn't work. RFRA tried something different. In RFRA, they said, if your religious freedom is burdened, it doesn't matter the context. Come to federal court and sue the state. So Archbishop Flores tries to sue the city of Bernie over basically a mundane zoning dispute, right? I mean, this is fairly boring stuff, right? They denied a building permit in federal court. So the question here wasn't just, were his rights violated? The question became, could Congress waive the city's sovereign immunity for a zoning dispute that imposed a burden on free exercise? That was the question, right? That was the question presented. So, Mai, what did the majority do here? What did Justice Kennedy do here?
They come up with
A test. Yes, a test. Most students' least favorite test in the entire book. Yeah, go ahead. So, what's our test here, Mai?
Let me find it. I believe it's a test that measures between their injury suffered versus the means of legislation.
That's a very good description. Yeah. Let's see. Where is this?
I don't know where it is.
Let me find.
Page 427.
Yeah. Yeah, so just read me out loud the test, please, Mai. It's a very confusing test. I'll spend a couple minutes on this because I know it doesn't make sense to anyone. I've been teaching this now for years. I still don't get it really.
Okay, so the stringent test RFRA demands of state laws reflects a lack of proportionality, oh my God, or congruence between the means adopted and the legitimate end to be achieved. If an objector can show a substantial burden on his free exercise, the state must demonstrate a compelling governmental interest and show that the law is the least restrictive means of furthering its interest. Is that enough? Or do you want
Very,
to-
very good. Thank you. So what's going on here, right? The court is doing a couple things here, and I want to separate each element of the court's decision because it all jumbles together. Yeah, people are nodding. So the first thing is the court says that Congress cannot redefine the meaning of the Establishment Clause. I'm sorry, the Free Exercise Clause, right? Congress cannot redefine the meaning of the Constitution. Who does that role fall to? The courts. This is like Marbury on steroids, right? Marbury does not say, be very careful, Marbury does not say that the courts have a monopoly in interpreting the Constitution. In fact, Marbury says all the departments have this duty. All the departments take an oath. But what the court says here is, oh, that's nice, Congress. You think you can interpret the Constitution? Bye-bye. That's our job, right? So the first basic aspect of Bernie is a declaration of what's called judicial supremacy, that the court, and only the court, gets the final say what the Constitution means. This is almost certainly wrong. I mean, it gets me almost angry. But there's nothing in the Constitution that says that 5 lawyers have a greater sense of what the Constitution means than 500 members of Congress. It just doesn't exist. It's nowhere to be found. You might like what the court says in some cases. You might hate what they say in other cases. You got to take the good with the bad. But I would much rather have a situation where Congress can actually vote on these things, how to interpret the Constitution, than the court. But that's not why I assigned this case. The reason why I assigned this case is that the court gives a test. The court gives a test to determine when Congress can waive a state's sovereign immunity. Right? They give you a test to show when Congress can waive a state's sovereign immunity. Right? It can be done, but only in very specific situations. And there's a concept known as means-ends scrutiny. Means-end scrutiny. What the hell does that mean? No, I'll tell you. So imagine we have a situation where Congress says, we're very concerned that states are depriving people of their religious freedoms, right? Right? So the injury is burdening free exercise of religion, right? That's the injury. Okay. That's an important injury, right? No one doubts that's an important injury. So what are you going to do about it? Well, what are we going to do? We're going to waive a state's sovereign immunity in every conceivable aspect so they can be sued in federal court. Wow. That's pretty broad, right? So you got an important injury, right? This burdening of religion. But you got a very broad, wide-ranging means, right? An approach to fix it. So Justice Kennedy says there's got to be a connection, a very tight connection between the means you're choosing to adopt and the end, the problem, right? You have to have a fit between the means and the ends. You have to have a fit between burdening of religion and these sorts of lawsuits. And so what the hell does congruence and proportionality mean? I still don't know. But it refers to how close the connection is, right? Congruent means roughly the same shape and size. Proportional means, following the same sort of dimensions. Congruent and proportional means you need a fit, a very tight fit between the means and the ends. We'll revisit this in the context of what's called strict scrutiny later this semester, right? We need to have a fit between the means and the ends. Is there a fit between RFRA and the lawsuits? The court says no. And why? Is there a burden of religion going on? Yes. But you have to target it in a more specific fashion, right? right? You can't just say, oh my God, you have a zoning dispute? Let's go to federal court. It has to be more narrowly tailored, right? A more specifically targeted approach to resolving religious freedom violations. So what the court says here is that there's not a congruent and proportional fit. There's not a tight enough fit between the burdens of religion and the sort of wide-ranging waiver of sovereign immunity, right? Now I want to jump ahead, right, to the last case. We'll come back to Bernie, I promise. But I want to jump ahead to the last case, which is the Hibbs. And the reason why I want to jump ahead to Hibbs is it provides a contrast, right? In Bernie v. Flores, the court found that there was not a close enough relationship between the means chosen and the injury to be fixed. However, in the last case, Hibbs, Nevada Department of Human Resources versus Hibbs, the court found that there was a close enough fit, right? So Gerald, do you want to give me the facts, please, in Hibbs? Yep, take your time. I know I jumped ahead a couple cases. We'll come back to Bernie in a minute.
Okay, so there was this Family and Medical Leave Act that was essentially it entitled eligible employees to take up to 12 hours.
12 hours?
I mean, 12.
Yeah.
12 work weeks.
That's a quick delivery.
Yeah, that's all right. Let's get it done and get back to it. No, so 12 work weeks.
Good,
one
yeah.
paid leave. And so the act created a private right of action to seek both equitable relief and money damages against any employer in any federal or state court.
Ah, and what if your employer was the State Department of Human Resources? Could you sue the state?
Yes.
And that's what happened here, right? So you have Mr. Hibbs. He was an employee who he sought leave under this FMLA, Family Medical Leave Act. He was denied leave. They gave him 12 weeks of leave, and then when he didn't come back, they fired him. Right? The law says you're not supposed to fire a person who takes this sort of leave. And he sued the state for damages. Okay? He sued the state for damages. Generally, if your state engages in some sort of misconduct, you have to sue them in state court. Right? There's certain ways you have to sue them in state court for discrimination or whatever, family-based discrimination. But he went to federal court, and he relied on FMLA. He said, I'm going to sue you because you didn't give me this sort of leave with a guarantee that my job is open the other side. So, Noel, was Mr. Hibbs allowed to bring a suit in federal court here? What did the court hold?
Yes.
Why? Why is Mr. Hibbs different than Mr. Flores?
Well, because there is that tight connection.
Ah, but let me ask the question differently, Noel. Why is RFRA different than FMLA, right? Why does FMLA work, but RFRA doesn't? Right?
Because it's both congruent and proportional.
Okay, in your own words, in English. Why does RFRA not allow suits against the state, but FMLA does permit suits against the state? What's the difference? Right? What's the big difference between the Family Medical Leave Act and the Religious Freedom Restoration Act? That's the question.
Because the state had a discrimination record and it was strong.
Ah, okay. Let me try this. So Mia, was RFRA at all limited to zoning disputes?
No,
What sort of disputes did RFRA apply to?
it applied to anything, new law, any state, local official, any law subject to challenge at any time.
Yeah, she's right. RFRA applied to everything. Any context in which a government official imposed a substantial burden on your free exercise. Now, Mia, in what context did the FMLA apply that a citizen can be sued his own state?
It was gender-based discrimination in the workplace.
But more specifically, what would trigger a violation? What specifically would trigger a waiver of immunity?
The violation of,
And what happened to Hibbs?
he was fired.
For-
Oh, yeah, okay, so it was
Yeah.
like anything from, if they give like very clear, like hiring
Yes.
practices,
Yes.
so application.
Yes, exactly. I wonder what you said. FMLA was very specific. It targeted, I think what Justice Franklin said, a fault line, right? A specific fault line, a specific attribute of the employment relationship. If an employee was fired or terminated or some sort of employment action was taken because of family-based leave, right? So again, RFRA was broad. Any aspect of human existence where a government official burned your religion, you could sue the state. It could be zoning. It could be an inmate in a prison, right? It could be, a child who's not given a kosher meal in a public school. It could be virtually anything. Whereas FMLA was much more targeted. It was targeted at a specific aspect of gender-based discrimination, a very specific aspect where you were terminated from your job because you didn't get this sort of protected leave. So therefore, the court found a congruence and proportionality between the means and the ends, right? What was the end? Gender-based discrimination. And what were the means? A civil lawsuit for employment actions. The connection between FMLA's means and ends was much tighter than the connection between Bernie's, RFRA's means and ends, right? So again, in Bernie, there was a huge gap between the means and the ends, and in Hibbs, there was a much closer connection between the means and the ends. And therefore, Justice Rehnquist cast a deciding vote to uphold the provisions of the FMLA that could then be sued, permit lawsuits against state officials. By the way, you could still sue a private employer under FMLA. Congress can always allow private employers to be sued, but the question is whether a state could be sued. Yeah, here's a line. It says, unlike the statutes at issue in the city of Bernie and Garrett, which apply broadly to every aspect of state employers' operations, the FMLA is narrowly targeted at the fault line between work and family, precisely where sex-based overgeneralization has been and remains strongest, and affects only one aspect of the employment relationship. So that's the majority. So any questions in the majority in Hibbs? Any questions in the Hibbs majority, or in Bernie for that matter? Yes.
Just a general knowledge question. So, for example, if I own a restaurant and then the city decide to do construction right in front of the street and there's no car can pass by and go to my restaurant, can I sue anybody?
Suing a city is easy. You just can't sue the state.
Right, but they wouldn't enjoin
Well, if it's
for that matter.
yeah.
Or would they give me like a compensation for my lost business because they deprived me of something?
I don't think it violates the Constitution. It's very beyond my knowledge, but there's probably a way. Probably. That happens a lot.
I'm curious because I drive around and I see poor restaurants.
No, it does. When this construction, restaurants go out of business. It's a serious issue. Yes, Kenesha.
So it was kind of interesting that Kennedy delivered the opinion for
Bernie. Yep.
and so Rehnquist joined him. And
Yep.
that he concurred, right? He didn't have any additional comments, right?
Nope.
But then in his,
Yes, ma'am.
Rehnquist delivered the opinion to Kennedy.
Yeah.
So I thought that was kind of interesting.
Did you see the thing in the video about that? And it's in the lecture. Mia, do you remember what the thing was?
That Ginsburg said that his daughter had just recently been divorced and
Yeah, this is one of those cases, Rehnquist was a bit of a squish. This came up a lot during the confirmation hearing, but Justice Rehnquist, not Chief Justice Rehnquist, Justice Rehnquist was fairly conservative. He was a Nixon appointee. So for his first 14 years on the bench, 12 years on the bench, he was fairly conservative. Then Reagan tapped him as the Chief Justice in '86. And there's a lot of statistics which show that after he became Chief Justice, he became a little more moderate. And he sort of moved to the middle, which often happens to the chief. They have this responsibility. So even though he joined the majority opinion Bernie with Justice Kennedy, Kenesha is exactly correct on that, he wrote the majority opinion in Hibbs, even though after Garrett and the other cases, Morrison. So something happened. And I noticed this Ginsburg gave a speech a couple years ago where she remarked that she said that the chief at the time, his daughter was a single mom, was in a rough spot, and he probably felt, maybe some empathy, dare I say, for family people who need to have family-based leave. It's hard, I think, I think you can distinguish Bernie and Hibbs. I do think there's a difference, right? The remedy at issue in Bernie was very broad. The remedy at issue in Hibbs was fairly narrow. The harder one is distinguishing Morrison from Hibbs. I think Morrison's a little bit tougher because we already studied Morrison with the Commerce Clause. But Morrison also had the issue that, if you remember, Christy Brazancala sued Virginia Tech. She was assaulted by 2 football players from the team. Virginia Tech is a state institution, and you can't sue a state college without their permission. So as part of the huge Morrison decision, the court found that Congress was not able to waive sovereign immunity. And even though it involved gender-based violence, she was raped. Even though it involved gender-based violence, the court found it wasn't enough. Why? Because it wasn't limited to any one specific type of violence. It was any gender-motivated violence. I think it was still too broad. So if I could, summarize, right? Bernie, look at my arms just for a minute, right? Up here. Notes, right? People keep writing, right? Imagine you have the means. Just look for 30 seconds. Go back to your papers, right? Right. Imagine you have, the means and the ends, right? Say in Bernie, there's a gap like this. And say in Morrison, it was maybe like this. And say in Garrett, it was like this. And then you get to Hibbs, it was like this, right? So you have a huge gap between the means and the ends in Bernie, and it shrinks a little bit in Morrison, and it gets onto Garrett like this. And then Hibbs, it's close enough to the Court of Appeal. So, I can defend Rehnquist's opinion without going to the stuff about his daughter or whatever. Maybe not, maybe it's a squish. But, that's what you call a judge who you don't like him, a squish, right? But I think you can defend it. But I do think there's distinction. Bernie was really broad, and then Morrison's a little bit more narrow about gender-motivated violence, and the ADA with the Americans with Disability, and then you get to Hibbs, which was pretty narrowly targeted, the fault line, I think, as Rehnquist phrased it. So I think that's how you reconcile these cases. This was a huge area of law in the 1990s and 2000s. This was a huge deal. Today it doesn't really matter as much. I don't know why it just doesn't get much play. Whatever settlement the court reached in Hibbs more or less resolved the question. And you don't have many lawsuits against states anymore. It just doesn't come up in recent years. Okay, so questions on Bernie or Morrison for that matter, or Hibbs or Garrett? Yes, Mia?
They focused a lot on how Congress proved the actual issue, the infringement of the right.
Mm-hmm.
Should we just focus more on the connection and the...
Well, we haven't done the 14th Amendment yet. I'm deliberately softballing it right now. But for example, a gender-motivated crime is a violation of the Equal Protection Clause, right? We haven't studied equal protection. A violation of free exercise violates a due process clause. The American Disabilities Act one's trickier because there's no express protection for disabled people in the Constitution. It's sort of this middle-of-the-road ground. So don't worry too much about the substantive provision versus the remedial part. Focus more on the waiver of the sovereign immunity. That helps you at all. Noel? What's your hand up? Okay. That's all I have. I don't need to keep you much longer. I think we can maybe break a little bit earlier. Are there any questions, anything in your mind? Yeah, Joe?
All right, this may be obvious, but it doesn't feel like obvious to me. Obviously, the state has sovereignty. Before we even get there, I could see why you would never want to. I'm just more curious if it's an option. obviously a state has sovereignty, and you can't sue them in federal court, can you still sue them in state court?
Well, so the trick about a state court is a state sets the jurisdiction of its own courts. So a state can say, our state courts do not have jurisdiction for certain types of cases. The more difficult question, one I've given a lot of thought, can Congress force a state court to hear certain types of cases? Flip side, can Congress tell a state court you can't hear these cases? So do you do in CIPRO exclusive jurisdictions? That's not familiar, that certain types of cases are only in federal court? What power does Congress have to divest a state court of jurisdiction? It's actually a really hard question. There's no good answer. Even things like immigration, patents, in the time of the founding, those were all state court issues, right? Our Constitution didn't create lower federal courts. It only created a Supreme Federal Court. So during the early years of the Republic, believe it or not, immigration cases went to the state courts. Not today. By what power did Congress divest state courts of jurisdiction, right? Could Congress pass a law that says state courts can't have domestic jurisdictions? All family law cases must go to federal judges. Really hard question. The answer is no, but very difficult questions. I read a paper on this, boring stuff. No one cares. It'll come up eventually.
Yeah, I thought that they like asked the courts to do it because they didn't have enough capacity.
Oh, they didn't. There were no federal courts at the outset. But once they built them, did they have the power then to tell the state courts you can't hear this case? Yeah, they've been doing it for a while.
You said that Congress can basically create a cause of action, like a lawsuit to private companies.
Oh yeah. Think of Katz and Vacuum McClung, right? Ollie's Barbecue, Heart of Atlanta Motel. If a private business engages in discrimination, and so long as it has a connection to interstate commerce that's adequate, then Congress can make it amenable to suit.
So then, but it has to be directed, the legislation has to be directed at the states though, right?
Well, are we talking about a private business or a state suit? All the cases we're talking about here are discrimination by the states and state institutions like state colleges, for example. A private business, Congress can get a cause of action very easily, so long as there's an adequate connection to interstate commerce, like the Heart of Atlanta Motel or the Ollie's Barbecue. Make sense?
So Morrison, they said that the law is okay if it's directed only at states where the evil was found, and they cited Katzenbach versus Morgan.
Yeah, that was part of Morrison. That I think they made findings that there was gender-based discrimination in like 21 states, but not 50 states, and they said that there wasn't an adequate enough finding of fact. That was similar to the Lopez and Morrison issue. Did they make enough findings about the effect on interstate commerce? Mm-hmm. And they found in Morrison that the findings were still not adequate. This was Joe Biden's baby. They didn't cross the goal line.
Which is why you're saying focus on the way of sovereign immunity.
I would focus there more.
Okay.
All right, let me summarize a bit. So under our current regime, right, we have the 11th Amendment, but it doesn't really matter, right, because states have their sovereignty. But Congress can waive that sovereignty so long as they find a close enough fit between the approach they're taking and the injury they're trying to fix. And generally, it's always permitting civil damages. So you focus on what are they permitting civil damages for. If there's a narrow injury, it'll probably be allowed. But if it's a broad injury like RFRA, like any sort of free exercise violation, it will not be allowed. I think that's your takeaway. All right. Are there any questions from the peanut gallery? From people watching at home? Does anyone put any comments? People putting comments on the thread. Look at this. Marcus and Justin. Present, me too. Marcus, I just saw you all at a bar before I left home to watch. You weren't going. Why be dishonest? Okay, JK. Okay, thanks. Okay, anything else?
Where does the law with the FMLA? Hibbs was only about public or the state.
Yeah, FMLA is good law applied to private businesses and state governments today. It applies to everyone equally. Make sense? Mm-hmm. Okay. All right, I'll see you all on Wednesday. Again, no class tomorrow. Enjoy your weeks. I had the reef attendance on. If you haven't checked it, please. Oh, I didn't turn it on. Okay, well, I'll do it now. No, I did. It's on.
I walked in a little bit late.
Oh, so you can check in now. That's fine. At home, you need to email me first. Don't check in. I'll know. Okay, at least I see 1 people checked in, 2 people checked in. They're not here. 3. Okay, a bunch of people checked in who aren't here. You have to count for this later. Okay. All right, anything else? I'll see you guys later.
Thank you.
Someone just